Okay, I think
Yes.
I can just
Yeah,
rejoin
yeah.
in a second.
No, it's okay. You can continue without your video on. You can share the
Oh,
screen. We are live now. Yeah.
okay, sure. Is the screen visible?
Yeah, yeah. It's visible.
So yeah, hello everyone. Good evening. I'm Ashutosh Kar. I secured an All India rank 10 in CLAT 2024, year 34 in ALIT 2024, and this is now one of my series where I talk about the legal reasoning section in particular. We've already finished a very vital section called the Law of Contracts, and we practiced a few questions about it as well. The videos will be available or are already available on the YouTube channel. And today we're going to begin with another important section, which is called Law of Torts. Now, this is also quite important from CLAT's perspective. Everything related to these laws, because you will be taught about them in the law school as well. It is definitely very helpful and will aid your preparation if you are familiar with the terminology and the type of questions that come from these topics. So yeah, let's get started today. I would like you to raise your hand or just unmute yourself and ask your doubts whenever I ask you to. So today's topic is law of torts. We'll start from the very basics. The introduction says that this word torts is derived from the Latin word tortum, meaning twisted or crooked. So this naturally gives you an impression that perhaps torts means something that should not have been done, something that has been twisted, some rule has been broken, some damage has been done. So what are the main characteristics of torts? The first characteristic is that one, it is a civil wrong. Now, torts is an entirely different branch of law. Apart from criminal, we have already read about contracts, so it does not include them. It is a civil wrong, which means it can be an action, a no in an inaction, or it may be a misaction. What does this mean? An action, or it can be termed as malfeasance. So what that means is you have done something that should not have been done. You have broken a rule. A great example for it is trespass. You have entered someone's private property where you are not legally allowed to go to. So that is an action which is a civil wrong. What is an inaction? An inaction, or also called as non-feasance, it basically means that you have committed an omission. So we can usually say that a crime is an act or an omission, right? So here also the torts can be consisting of some act which was wrongful, which was against the rules. Some inaction means you were supposed to do something, तुम्हें कुछ करना था, you should have been doing that, but you have not done it. One of its examples is, for example, you are not using your indicator in your vehicle. Or it can be a misaction. मतलब तुमने कुछ काम किया तो है, but that work that you did, you were supposed to uphold a particular level, right? You owed a duty of care to someone, and your work was not satisfactory. Your work consisted of some kind of misaction or misfeasance, which means an example for it is medical negligence. We've all heard of stories, right? किसी के organ में कोई instrument छूट जाना. So that is something that the doctor's fault lies. So this is also a part of torts. Now let me make it clear. Even though it is a civil wrong, we will be reading about few examples of torts. A few examples such as defamation or nuisance and negligence. We'll read about all of this in detail, assault, battery. So some of this may also find a place in the branch of criminal law, but it can also be acted on, or there can be a lawsuit based on the torts as well. So we'll continue and show what distinguishes this field from other fields. So we've already said that a civil wrong can be an action, an inaction, or perhaps a misaction. It that fails the expected legal standard or reasonable man criteria. So this is not a criminal offense, but is rather a violation of the personal rights of an individual, which has civil consequences as opposed to punishments in criminal law. A civil wrong, which is a tort, is also not a breach of contract or trust. So while torts are civil wrongs, all civil wrongs are not torts, because they will also inevitably include a breach of contract or that of a trust. So a tort is basically something that has occurred where you have committed some kind of civil wrong that has failed a reasonable level of expectation from you. You owe a general duty of care and an obligation obligation to act a certain way in the society so that everyone can function and get on with their lives as they're doing. But if you violate that, you are damaging someone's personal rights, which you must have some kind face some kind of civil consequences, right? But these consequences are not jail or which you face when you are violating some kind of law in the Indian Penal Code, let's say. So what kind of violation occurs here? Here there is something called a legal damage or an injury, which is different from an actual damage. Let's say your father has slapped you because of some action that you did. You cannot you have indeed faced an actual damage, right? But here there is no legal damage. If you are under the age of 18, you are living in the under the authority of your parents, and if the slap was not something that was veering towards child abuse, you cannot do much about it because there was no legal damage. We'll talk about this using two maxims in torts. Injuria sine damno is actionable. What does this mean? Injuria matlab injury, sine matlab without, and damno means damages. So if there has been an injury, which means a legal damage or a legal injury in this context, without any damages, it is still actionable. But a damage which has occurred without any corresponding legal injury, that will not be actionable. We'll talk about it in the next slide. So here we'll discuss two important cases. Again, there is no need for you to learn the cases by heart or something. It is just for your understanding and so that you're able to better deal with the situations presented in the questions in your mock tests. So the first case is Ashby versus White. What is this case? The plaintiff, okay, let me just clear it up. A plaintiff is someone who files a lawsuit against someone. The defendant is someone who's expected to defend his actions and advocate for him that no, I do not deserve to be convicted. So here, Ashby versus White means this is a case where the plaintiff was an eligible candidate to vote, right? We all have the right to vote in our elections. But what happened there was he or she was not allowed to cast his vote by the returning officer. So जो रिटर्निंग ऑफिसर होता है जो आपको वोट कास्ट करने के लिए हेल्प करता है, उन्होंने इसको रिफ्यूज कर दिया. So basically here the case is being filed by someone who is a rightful voter, who has the legal right to vote, but the defendant against whom the case has been filed is the returning officer who has not permitted this action to take place. So here no loss was caused because of refusal by the defendant, as the candidate whom the plaintiff intended to vote for won the election. So तुम जिसे वोट करना चाहते थे but you were not able to because तुम्हें allow नहीं किया गया, that candidate has won. So here there is no actual loss, right? There is no damage here, without damage. However, the House of Lords in England decided that the defendant was liable when the plaintiff brought a suit against the defendant, as if the plaintiff has a right. He must be permitted to enjoy it without any prevention, and if so, the remedy should be provided. So there is a maxim also called where there is a right, there must be a remedy, because if your right has been violated, you must be allowed to enjoy it. And agar वैसा नहीं किया गया है, you have the right to file a suit against the defendant, and the defendant will also be liable. So I hope you understood the concept of injuria sine damno here. In the second case, in the Indian context, Bhim Singh versus State of Jammu and Kashmir. So Bhim Singh was the plaintiff in this case, who was an MLA of the Jammu and Kashmir Assembly. Okay, so here one MLA is being detained by the police while going to the assembly session. So you know that there is a legal right of the MLA to attend the assembly session because they have been elected as the representative of the people of a constituency. He was not produced before the JM, perhaps a magistrate, within the prescribed time. Also, we know that every person who has been detained by a police has the right, or who's been jailed, has the right to be presented before your magistrate within a prescribed period of time. Because of this, he was deprived of his constitutional right to attend the assembly session. And also there was violation of fundamental rights of personal liberty guaranteed under Article 21 of the Constitution of India. So here two rights were violated. Firstly, he had the constitutional right as an MLA to attend the assembly session. Secondly, because he was not presented before the magistrate within the prescribed time, as should anyone else be, there was also a violation of fundamental right of personal liberty. Okay, so you may say that here there is no damage because he is allowed to attend the session from the next day onwards. Maybe he was just detained for a few hours, but whatever happened, his rights were violated. There was an injury without damage. He has been awarded a compensation of 50,000 rupees along with his release from jail. So I hope you understood what legal damage means and how it is different from an actual damage. Maybe no damage occurred here in the case of the election, but since the rights were violated, you can say that there has been some kind of an injury, and that is what matters in the cases of in the case of torts. So does anyone have any doubt with respect to this slide till now? All right. So we'll head to the next maxim, which talks about, yeah, go ahead. Okay. So we have next maxim, which is called damnum sine injuria, which means there have been some damages, but without any injury. So how can this happen? For this, we'll look at a case which is called Gloucester Grammar School case. इधर क्या हुआ था? The defendant, who was a schoolmaster, started a rival school opposite to a plaintiff school. So let's say तुम्हारा एक school है, तुम जिसे चला रहे हो, and you had someone who was your employee. You had some kind of a feud. वो पर्सन चला गया तुम्हारे स्कूल से, एंड उसने क्या किया, तुम्हारे स्कूल के पास ही एक राइवल स्कूल खोल दिया, एंड जिसकी वजह से अगर वहां पे और एक स्कूल है जो ऑफर कर रहा है स्टडी एजुकेशन एट अ चीपर प्राइस, inevitably a lot of your students will go away to that school. Because of this, जिसका स्कूल है, original school, the plaintiff school, he had to reduce his school fees, and due to that he suffered loss. So his plight was, इसने मेरे स्कूल के पास ही जानबूझ के और एक स्कूल खोल दिया, जिसकी वजह से I had to reduce my fees and I have been suffering some financial loss. So when he filed a suit to claim compensation from the defendant, the court held that without violating the legal rights of a person, even when there is a loss, it is not maintainable. The suit is not maintainable. Why? Because even though यहाँ पे तुम्हारे लिए कोई damage हुआ है, you have been facing some kind of an injury, right? But still, you are facing some kind of damage, but there is no injury. Why not? Because the person who has opened a school has done so lawfully. He has every right to do so. तुम्हारे दुकान के पास ही कोई और एक दुकान खोल ले, कंपटीशन बढ़ जाए, that does not mean you will have the right to file a lawsuit against that person, right? Because everyone enjoys the freedom to trade of any occupation. So here, the suit was not maintainable. So under torts, damnum sine injuria, which means you have faced some damages without any injury, which in the context of this means a legal damage. It means that it's not actionable. Only when you have been facing some kind of a legal damage can you file a lawsuit. So is everyone clear with the distinction between these two maxims? You won't be required to remember them by heart. You just need to understand the distinction between them. So we'll head to the third component, or the characteristic of torts, which means legal remedy. So अगर कोई damage हुआ है and जिसके लिए तुम मतलब कोर्ट पे गए हो, what exactly are you expecting there? Are you expecting the other person to be jailed? No. In torts, the damage in torts should be actionable, which means redressable, जिसको हम भरपाई कर सकते हैं. कोई किसी का लॉस हुआ है तो उसको कॉम्पेंसेट करते हैं, वैसा ही हो रहा है यहाँ पे. Redressable by unliquidated damages. What does this term unliquidated damages mean? It means damages मतलब क्या है समझ लो. Damages मतलब जो मतलब suppose तुम्हें 5 लाख रुपीस compensation मिल रहा है किसी से, that is what damages means. And ये जो amount है 5 lakhs का, ये pre-decided नहीं है. जैसे कि तुम देखो, अगर तुम criminal law देखोगे, you have IPC, you have various sections of various crimes, and for that crime there has been a minimum period of imprisonment, advocated for, or there is some kind of a fine which has been there. So that has been something which is decided, and जिसको further वो judge rule करेगा. But unliquidated का मतलब ये होता है कि it has not been pre-decided. It's rather left at the discretion of the court based on the facts of the case. So like fact by fact basis पे जब एक पार्टी आके केस फाइल करता है, उसके grievances मतलब सुनता है कोर्ट, and after that they make a decision, they reach a consensus कि अच्छा here this much amount of compensation should be awarded. So this means unliquidated damages. मोस्टली इसी के थ्रू ही रिड्रेस किया जाता है इस केस में. टॉर्ट्स में लीगल रेमेडीज यही होता है. बट इन सम केसेस, फॉर एग्जांपल इन केस ऑफ अ न्यूइसेंस, यू कैन फाइल एन इंजंक्शन. So what does an injunction mean? It's something that the court tells you to stop doing something. You're prevented from doing something. जो तुम कर रहे हो, अगर वो किसी के राइट्स को वायलेट कर रहा है बार बार, उसके लिए the court can say कि injunction फाइल हो रहा है, so you will be prevented from doing that. और स्पेसिफिक परफॉर्मेंस. स्पेसिफिक परफॉर्मेंस मतलब तुम कुछ काम नहीं कर रहे हो, तुम्हें कोई फोर्स कर रहा है कि यू हैव टू अपहोल्ड योर पार्ट ऑफ द बार्गेन एंड डू दैट एक्टिविटी, राइट? सो इन द केस ऑफ defamation or nuisance, you have these two alternatives. But usually the unliquidated damages are awarded to the person whose rights have been violated in the case of a tort. There cannot be a tort if there is no legal remedy. These are essentially compensatory and seek to place the defendant in the position that he would have been had the wrongful act not been committed. तुमने जो wrongful act commit किया जिसकी वजह से किसी को damage face करना पड़ा, अगर तुमने वो काम नहीं किया होता तो essentially वो defendant जिस position में होता उसी position में the court tries or strives to return that position, right? So that तुम्हारा compensation हो जाए. And there is another note. So you may think कि अच्छा right, तो crimes के लिए criminal law हम Indian Penal Code से पढ़ते हैं. Contract law we already studied through Indian Contract Act. So what is this law of torts? मतलब ये आया कहाँ से? जैसे कि family law के भी बहुत सारे statutes हैं इंडिया में, like you know your marriages are being governed by some kind of an act and so on. But the law of torts is uncodified. Uncodified का मतलब क्या है? It did not develop from a statute or an act passed by the parliament, but from centuries of judicial precedents based on case decisions in English courts as well as other common law systems. So I hope you already know there are two kinds of systems predominantly followed all across the world: civil law and common law. Common law is something that is followed in India as well, and England and other countries such as US, where previous decisions rendered by courts or judicial authorities are treated as law as well. So they become precedents and law of the land. So in that manner, law of torts कोई legislature के द्वारा पास किया गया act नहीं है या फिर statute नहीं है. Rather, it has evolved through centuries of these decisions which have been taken in English courts. We'll read a few of these famous ones: Rylands versus Fletcher and MC Mehta versus Union of India as well. So these are all part of the syllabus here. So now that we're done with the introductory part, what law of tort consists is, firstly, there has been some kind of a civil wrong, not a breach of... Yeah, does anyone have any doubt? There has been some kind of a legal damage. And thirdly, there is some kind of a legal remedy which will help you to compensate for that damage. Okay, so before we head to the distinction between tort and a crime, tort and a breach of contract, I would like to again repeat if anyone has any doubts about what we just studied. I hope you're clear about the two maxims: damnum sine injuria and then injuria sine damno. So now let's talk about how this field is different from crime. A crime is something that occurs as a public wrong, whereas a tort is a private wrong. इसका मतलब क्या है? जब तुम कोई crime करते हो, when let's say there has been a murder, that murder is a crime which is a wrongful action against the wider public. You probably know by now that वो जो crimes होते हैं, where the proceedings against the accused are brought by the state. There is a public prosecutor. I hope you understand that. They have the duty to prosecute these individuals who are accused of various crimes, right? तो वो कैसे करता है state? Murder तो किसी एक person का हुआ है, लेकिन the action can be initiated by the the state government as well. So that is what a crime is. A crime is treated as a public wrong, and to set a precedent कि आज से ऐसा कोई और नहीं करे. That is why the prosecution is started by the state as well. Whereas a tort is a private wrong. तुम किसी के property में चले गए, there has been a trespass. Here the wrong is not against the public, but rather against a particular injured party जो कि एक suit file करता है तुम्हारे खिलाफ against the wrongdoer. Crimes में the elements may vary, जबकि torts में the elements are already determined. I've already told you the three main elements of a tort, right? So there is a civil wrong, there is a legal damage, and there is some kind of a legal remedy for that damage. Next, crimes में तुम कोई settlement नहीं कर सकते हो, except in some cases. For example, if there is a case of a rape, you cannot settle among yourselves कि अच्छा चलो हम और नहीं जाएंगे कोर्ट को. जबकि in case of a tort, compromise can be reached at any stage of the case between the parties. वो आपस में बात करके सुलझा सकते हैं केस को. In a crime, remedy is none other than the punishment, except one or two cases of CRPC or paid out of fine. So in crimes, as you have already known, there are various statutes such as IPC, CRPC, and all of this lays out a procedure कौन सा punishment लेना है, कहाँ पे fine कितना लेना है. जबकि in torts, usually the remedy is monetary compensation decided by the court depending upon the facts of the case. Imprisonment and arrest is penalty. Imprisonment and arrest is pressure to perform the duty. So see, crime में the main penalty that you face may be imprisonment and arrest. जबकि torts में वो नहीं होता है as long as you are agreeing to this compensation which you have been mandated to provide. Let's say court order किया है कि तुम उसे 5 लाख रुपए भरपाई दो, compensate him for the damages which he or she has faced, and you have refused to give that amount. तब जाके तुम्हें प्रेशराइज करने के लिए, तुम्हारे ड्यूटी को परफॉर्म करने के लिए, यू मे बी फेसिंग इम्प्रिजनमेंट एंड अरेस्ट. अदरवाइज इट्स यूजुअली नॉट द केस इन केस ऑफ टॉर्ट्स. अब टॉर्ट और ब्रीच ऑफ कॉन्ट्रैक्ट में क्या फर्क है? कॉन्ट्रैक्ट में भी तो सिविल रॉन्ग ही होता है ना. कॉन्ट्रैक्ट में थोड़ी तुम जेल चले जाते हो इंस्टेंटली. देयर इज आल्सो अ प्राइवेट पार्टी, तुम दोनों के बीच केस चलता है. बट व्हाट द डिस्टिंक्शन बिटवीन दीज टू फील्ड्स इज that torts में the breach of duty is imposed by law on members of society. Let's say तुम किसी के घर के या टेरिटरी प्रॉपर्टी में चले गए, प्राइवेट प्रॉपर्टी में, इधर देयर इज नो कॉन्ट्रैक्ट, प्रायर कॉन्ट्रैक्ट बिटवीन यू टू, राइट? तुम जिसके घर में चले गए, द हाउस ओनर एंड यू डू नॉट हैव एनी प्रायर कॉन्ट्रैक्ट बिटवीन योरसेल्फ. तो तुम किसको ब्रीच किया तुमने? What you breached was the duty which is imposed by law. There is some kind of a reasonable expectation from you to behave in society, right? So वो ड्यूटी को तुमने ब्रीच किया है. जबकि in a breach of a contract, the breach of duty is undertaken by the parties themselves through the agreement. तुमने पहले से agreement reach किया था जहां पे you had laid down these conditions कि ये चीज तुम्हें करना होगा, and if you are not doing that, you are actually committing some sort of a breach. So here there is a distinction between them. The duty is not based upon privity of contract. The duty is based on privity of contract. If you are attended the previous classes, you would already be familiar with this principle. What is a privity of contract? It means that जो दो parties contract के parties हैं, उनके बीच ही केस फाइल किया जा सकता है. कोई थर्ड पार्टी आके फाइल नहीं कर सकता केस उनके बीच. जबकि इन टॉर्ट्स you cannot say कि अच्छा हम दोनों के बीच तो कोई contract था ही नहीं, he is a third party, he cannot file a case against me. No, that's not how it works, because the duty here is imposed by law and is not based on privity of contract. The damage in case of torts is unliquidated. Unliquidated का मतलब, I hope you remember, it has not been pre-decided. It's decided by the court or whatever jury in some other country based on the facts of the case. जबकि in the breach of a contract, usually तुम्हारे agreement में ऐसे terms and conditions होते हैं कि अगर ये breach हुआ तो इतना damage देना पड़ेगा. You sometimes, most of the times, the damage is liquidated. मतलब it's already been laid out previously. So does anyone have any confusion regarding this field of law of torts? Feel free to drop any doubts. So let's talk about a few more clarifications. Privity of contract versus tortious liability. I just talked about this, and we'll delve into this in a deeper form. So A is someone who has entered into a contract with B. Okay. So A is answerable only to B, and B is answerable only to A, and not to any of the strangers. This is what privity of contract means. Contract is between two parties here. For this, the best example case is Donoghue versus Stevenson, which is popularly known as the ginger beer case. इसमें क्या हुआ था? So देखो, A went to a restaurant. तुम एक restaurant गए थे तुम्हारे दोस्त के साथ, and you bought a bottle of ginger beer manufactured by the defendant, जिसके अगेंस्ट तुमने केस फाइल किया है. तुम्हारे साथ जो तुम्हारी एक मतलब दोस्त गई है, she consumed half of the contents. When the remaining part was poured into a glass, they found the decomposed body of a snail. तुमने खरीदा है वो बियर का बॉटल, एंड कंज्यूम किसने किया? तुम्हारे दोस्त ने किया जो तुम्हारे साथ गई थी. शी हैज ड्रैंक ऑलरेडी हाफ ऑफ द कंटेंट, एंड वो लैटर हाफ को जब पोर करती है, दे फाउंड कि एक स्नेल का डिकम्पोज्ड बॉडी गिरा हुआ है. सो ऑफ कोर्स दिस इज अनहेल्दी. As the beer was served in opaque bottle, A was not able to see the contents in the bottle. The woman friend brought a suit against the manufacturer of the beer for negligence and serious illness as a consequence. तुम्हारे साथ जो दोस्त गई थी, she filed a suit against the manufacturer कि how could you do this? तुम्हारी वजह से मुझे serious illness face करना पड़ा है. So you are liable for negligence. The manufacturer जिसने वो beer बनाई थी contended that they had no contract with the consumer but only with the restaurant who sold the drinks. तुम एक रेस्टोरेंट में जाके ड्रिंक्स परचेज किए हो, which means जो मैन्युफैक्चरर बोल रहा है कि हमारी मतलब जो लाइबिलिटी है वो तो सिर्फ रेस्टोरेंट तक है, कॉन्ट्रैक्ट हम दोनों के बीच था. वी हैव नो कॉन्ट्रैक्ट विद द कंज्यूमर. सो टेक्निकली अगर तुम सिर्फ लॉ ऑफ कॉन्ट्रैक्ट्स के बेसिस पे देखो, यहाँ पे तो कोई लाइबिलिटी नहीं अराइज होती है. दे प्लीडेड दैट ओनली द शॉपकीपर इज लायबल एंड नॉट देम. जिस शॉप या रेस्टोरेंट ने तुम्हें वो ड्रिंक बेची है, only they are liable. They should be facing some kind of a consequence, and we are not liable. The House of Lords rightly observed that the manufacturer owes a duty to all those who intend to consume his product. Here, the House of Lords brought in the Law of Torts. Thus, in Law of Torts, liability is based on duty imposed by law and not on the basis of a contract. All right, although there is no actual existing prior contract between the manufacturer of the beer and the one who consumed it, because the contract was only between the manufacturer and the shopkeeper or the restaurant to whom the beer was sold, and the further contract was established only between the restaurant and the consumer. The duty of care that you have towards every member in the society जो भी तुम्हारा product consume करे, you cannot avoid that. That's why you are liable. Is anyone confused about this? Donoghue versus Stevenson? All right. Now I'll talk about the overlap. I told you that there are some instances where a similar act will fall under both laws. Tort भी हो सकता है या crime भी हो सकता है, in which the remedies are available concurrently. इसका मतलब ये है कि अगर दोनों के अंडर you are facing some kind of a action, तुम्हारे अगेंस्ट कोई टॉर्ट पे भी केस ला सकता है या फिर तुम्हारे अगेंस्ट कोई क्राइम पे भी केस ला सकता है. There are remedies available under both. There would be a civil action by the plaintiff, which means compensation तुम्हें देना पड़ सकता है, या फिर there can be also a criminal action, the wrongdoers would be punished. The prime example of this is, I hope you remember, Rahul Gandhi faced a criminal defamation charge under which the minimum imprisonment was 2 years, after which he was subsequently disqualified from the parliament, right? So defamation is something that can fall under Law of Torts. You can file a civil suit, civil defamation, or you can file against the person criminal defamation. In America, to prove criminal defamation, you will have to show that there was an actual malice. मतलब जो defame किया है तुम्हें, he or she had an intent to do so, right? So this is the distinction between them. Civil भी हो सकता है case या criminal भी हो सकता है. So the wrongdoer can be punished under either of the cases. All right. So there will be some overlaps which you may find. So I hope it's clear. Now, what we'll talk about the rest of the class is defenses to torts. We'd already talked about कि torts के अंदर कैसे case कोई file कर सकता है, कैसे किसी को injury हो सकती है, legal damages, and how he or she can seek remedies in return for that damage to be compensated. Now we'll look at a few defenses जिसके बदले तुम्हारे अगेंस्ट कोई केस फाइल करे, अगर लॉ ऑफ टॉर्ट्स के अंदर तुम डिफेंडेंट हो, देन यू हैव सम डिफेंसेस फॉर योरसेल्फ. तुम ये बोल के अवॉइड कर सकते हो कॉम्पेंसेशन देना. क्या क्या बोल के? द फर्स्ट वन व्हिच विल स्टडी अबाउट इज वॉलेंटी नॉन फिट इंजुरिया. आई होप द स्क्रीन इज विजिबल टू एवरीवन. कैन समवन कंफर्म?
Yeah.
Okay. So what this maxim text tells you about is, this is the first defense which we'll study about, and we'll solve a passage given here which came in CLAT 2022 if I'm not mistaken. So volenti non fit injuria states that when a person voluntarily agrees to suffer some harm, he has no remedy for that tort. अगर तुमने अपने कंसेंट को दे के यू हैव अग्रीड कि अच्छा एक चांस है कोई हार्म होने का, मुझे सम लीगल इंजरी हो सकता है, मुझे मतलब कोई डैमेज हो सकता है, if you have agreed to it voluntarily, it does not constitute a legal injury. All right. So this consent to suffer that harm may be expressed or implied. Volenti, as you may understand, which means voluntary. Non-fit injuria, if you have agreed to something voluntarily, you are not fit to file की a case की मुझे कोई legal injury हुई है. Okay, so here if you invite someone to your house, तुमने खुद उन consent को देके you have agreed कि कोई तुम्हारे घर को आएगा, right? So here you cannot later file a case against someone कि तुम मेरे घर को कैसे enter कर लिए बिना permission. You cannot accuse them of trespass. This is a really basic example. We'll talk about more complicated details going ahead. In games such as football or cricket, players are deemed to agree to any hurt likely in the normal course of the game. जब तुम एक player हो, तुम bat पकड़ के खेल रहे हो, you are aware of the risk which the game entails. कभी ball तुम्हारे organs को लग सकती है, right? So you have already been deemed to agree to any hurt likely. तुम किसी के against case नहीं file कर सकते उसकी वजह से. For this defense to be available, for volenti non-fit injuria to be there to rescue you from this case, the act causing harm must not go beyond the limit of what has been consented to. consent must be free. Okay, अगर तुम्हें ये डिफेंस अवेल करना है, देन जो प्लेंटिफ है, जो तुम्हारे अगेंस्ट एक केस फाइल कर रहा है, he or she must have agreed to something, and जो हार्म हुआ है वो मतलब वो अग्रीमेंट के अंदर ही हुआ है, right? The harm must not go beyond what has been consented to. This is a case Lakshmi Ranjan versus Malar Hospital. इसमें क्या हुआ था ना, a lady who was under surgery, like when she woke up, she realized that उसका मतलब यूटरस हॉस्पिटल ने निकाल दिया है. Okay, so here she was infuriated, of course. The court found Malar Hospital Limited liable for inadequate service and unauthorized medical intervention. क्यों? क्योंकि लक्ष्मी रंजन का जो कंसेंट था, it was obtained under duress here. The consent must be free. Okay, the consent जो plaintiff दिया है कि हाँ I agree to suffer this much harm, it must be free. जबकि she was under a sedated state and तुम तब उसके बिना परमिशन उसका यूटरस रिमूव नहीं कर सकते थे. Okay, so the hospital was supposed to restrict their activities only up to the consent. जितना consent तुम्हें दिया गया है तुम्हें उतना ही करना था. तुम्हें एक falsely assume करके कि हाँ हम उसके भलाई के लिए कुछ कर रहे हैं, so वो assume करके तुम कुछ नहीं कर सकते, right? Mere knowledge also does not imply assent. If a person who is aware of the risk, वो automatically नहीं ऐसा होता कि he or she has also agreed to the risk. We'll talk about it elaborately in the passage. To avail the defense, 2 points are needed. To avail this defense, 2 points satisfy होने चाहिए. The plaintiff knew that the risk was there and he, knowing the same, agreed to suffer the harm. जो plaintiff तुम्हारे against case file किया है to seek damages, he or she was already aware कि एक ऐसा risk है and उसने agree भी किया था suffer करने को. उसके बाद वो तुम्हारे against और case नहीं file कर सकता because you have this defense की Volenti non-fit injuria. All right. So harm suffered. We'll start this passage. Legal reasoning under this was a previous year CLAT paper. Harm suffered voluntarily does not constitute a legal injury and is not actionable. This principle is embodied in the maxim volenti non-fit injuria. A person cannot complain of harm to the chances of which he has exposed himself with his free consent and free will. The maxim volenti non-fit injuria is founded on good sense and justice. जो पर्सन खुद इनवाइट किया है वो हार्म या फिर असेंट किया है एक एक्ट को जो तुम्हारे तरफ किया जा रहा है, जब तुम उससे सफर करते हो तब तुम जाके नहीं कंप्लेन कर सकते कि तुम्हारे खिलाफ कोई गलत चीज हुई है, राइट? The maxim presupposes a tortious act by the defendant. The maxim applies in the first place to intentional acts which would otherwise be tortious. मतलब अगर वैसा कोई कंसेंट नहीं होता तो एक्चुअली you should be giving the damages. अगर तुमने वैसा कुछ काम किया है जिसकी वजह से तुम्हारे अगेंस्ट केस फाइल किया हुआ है, that means you should be liable, but the only reason you are not liable is because the plaintiff जिसने तुम्हारे अगेंस्ट केस फाइल किया था वो ऑलरेडी उसको voluntarily agree कर चुका है. But there are certain limitations. ये डिफेंस हर जगह अवेलेबल नहीं होगा. क्या क्या limitations होंगे? Firstly, it is no answer to a claim made by a workman against his employer for injury caused through a breach by the employer of a duty imposed upon him by a statute. Where the negligence or breach of statutory duties on the part of an employee of the plaintiff who knowingly accepts the risk flowing from such breach and the employer defendant is not guilty of negligence or breach of statutory duty, the defense of volenti non-fit injuria is available to the defendant. So let's break it down. यहाँ क्या बोला जा रहा है कि देखो, in a workplace there is some kind of relationship between the employer and the employee. अगर कोई workman जो काम कर रहा है वो अपने एम्प्लॉयर जिन्होंने उसको एम्प्लॉय किया है उसके अगेंस्ट कोई क्लेम फाइल कर रहा है फॉर इंजरी कैसे हुई? अगर दैट इंजरी हैज बीन कॉज्ड थ्रू अ ब्रीच बाय द एम्प्लॉयर ऑफ अ ड्यूटी इम्पोज्ड अपॉन हिम बाय अ स्टैट्यूट. For example, there are a lot of laws which regulate this labor process. Labor laws are codified principles which the employer must obey. So मतलब देखो, every factory has some minimum level of safety, right? ये सेफ्टी गाइडलाइंस अगर वो एम्प्लॉयर फॉलो नहीं कर रहा था देन दैट इज अ ब्रीच ऑफ हिज ड्यूटी. एंड तब अगर कोई एक्सीडेंट होता है देन द वर्कमैन हैज द राइट टू फाइल अ क्लेम ऑफ टॉर्ट अगेंस्ट दैट एम्प्लॉयर. एम्प्लॉयर तब नहीं बोल सकता कि हाँ ये तो एक रिस्क है यहाँ पे काम करने का, फैक्ट्री में काम करने का, ये रिस्क तो पता था जो वर्कमैन को, how is he filing the case? No, because here the employer is also negligent. He has not followed his duty which has been imposed upon him by various labor regulations, let's say. Where जहां negligence या breach of statutory duty employee के part हो, मतलब देखो जो एम्प्लॉयर है वो तुम्हें हेलमेट भी दिया है, सारे सेफ्टी इक्विपमेंट्स दिया है, अच्छे से लैडर दिया है, सारे काम वो जितना कर सकता था उतना सेफ्टी मेजर्स लिया है, बट इट इज ऑन योर इट इज इनकम्बेंट अपॉन यू टू बी केयरफुल आफ्टरवर्ड्स। अगर तुम खुद के मिस्टेक्स की वजह से, अगर तुमने हेलमेट नहीं पहना था, वो तो तुम्हारे मतलब ब्रीच ऑफ ड्यूटी हुआ ना। सो यू हैव नोइंगली एक्सेप्टेड कि अगर मैं ये ऐसा ब्रीच करूं, अगर मैं हेलमेट ना पहनूं, देयर इज अ सर्टेन रिस्क टू इट। So the employer defendant, the employer जिसके against case file किया गया है by the employee, is not guilty of negligence or breach of statutory duty here. Either defense of non-fit, voluntary non-fit injury is available. So did anyone have any doubt regarding this point? It is an exception to this maxim कि voluntary non-fit injury is a defense available to the defendant.
What about the Bhopal gas tragedy?
Yeah, the Bhopal gas tragedy was a case जहाँ पे कि the factory was not observing the required safety regulations. All right, that is why later on the government of India tried to sue them and ensure that they paid the damages, the compensation in that case. We'll reach that in the case of some cases. There are two kinds of principles: strict liability and absolute liability. The point you brought up is it is under the law of torts as well, but it is something where it comes under absolute liability. अगर तुमने सारे duty of care किया भी है तब भी तुम liable होगे in that case. We'll talk about it in the next class. I hope your doubt was clear.
Yeah.
Under an exigency caused by the defendant's wrongful misconduct, consciously and deliberately faced a risk, even of death, whether the person endangered is one to whom he owes a duty of protection as a member of his family or is a mere stranger to whom he owes no such special duty. The rescuer will not be deprived of his remedy merely because the risk which he runs is not the same as that run by the person whom he rescues. But where there is no need to take any risk, the person suffering harm in doing so cannot recover. So इसके लिए I will give you an example. एक person था who had left his horse unattended. The horse was एक horse का cart था, so जिस पे बैठ के वो जाता था. उसने क्या किया था, अपने घोड़ों को वैसे छोड़ दिया था street पे unattended, and two little kids came and they messed with the horses. The horses ran rampant across the streets and they were damaging the property as well as injuring some people. A police officers ran after the horses. He suffered various kinds of injuries to rescue the other public citizens and ultimately stopped the horses. Yahan, the person who was the owner of the horses cannot claim the defense of voluntary non-fit injuria. He cannot say कि अच्छा पुलिस ऑफिसर ने तो खुद कंसेंट किया था घोड़ों के पीछे दौड़ते वक्त टू कंसेंट टू दैट इंजरी. ही वाज अवेयर कि ऐसा हो सकता है and he still did so. So I am not liable to give any kind of damages. Why this is an exception? Here is an exception because if this is a sort of a risk जहां पे कि डिफेंडेंट के wrongful misconduct की वजह से हो रहा है, a person endanger होता है, किसी की लाइफ खतरे में है, वो पर्सन चाहे वो पुलिसमैन का भाई डेंजर में हो या फिर पुलिसमैन कोई भी रैंडम इंसान को देखे जो कि डेंजर में है वो हॉर्सेस से, इधर द रेस्क्यूअर द पुलिसमैन विल नॉट बी डिप्राइव्ड ऑफ हिज रेमेडी जस्ट बिकॉज वो उसको पता था वो रिस्क, राइट? बट अगर रिस्क लेने की कोई जरूरत ही नहीं थी, देन द पर्सन सफरिंग हार्म इन डूइंग सो कैन नॉट रिकवर. फॉर एग्जांपल, लेट्स से तुम्हारे बाजू के घर में आग लगी है, राइट? देयर इज अ फायर देयर. Now you are already aware कि firefighters पहुंच चुके हैं and they are inside the house trying their level best to extinguish the fire. As such, there is no need for you to delve into that risk, but you are still running into that burning house and trying to rescue others. So there is no need to take any risk. So the person suffering harm in doing so cannot recover. तुम यहाँ पे कोई केस नहीं फाइल कर सकते जिसकी वजह से आग लगी है कि अच्छा तुम्हारी वजह से मुझे डैमेजेस हुए, because you did not have to go into that house, right? The third point states that in order to cover a case of negligence, the defense on the basis of the maxim must be based on implied agreement, whether amounting to contract or not. The defense is available only when the plaintiff freely and voluntarily, with full knowledge of the nature and extent of the risk, impliedly agreed to incur it and to waive any claim for injury. So देखो, अगर एक केस है नेग्लिजेंस का सबसे इजी एग्जांपल मेडिकल नेग्लिजेंस बोल रहा हूं मैं. विल टॉक अबाउट ऑल ऑफ दिस इन डिटेल व्हेन वी कवर these cases in the next class. So here अगर तुम्हारे डॉक्टर ने कुछ ऐसा किया है जिसके अगेंस्ट यू कैन फाइल अ सूट फॉर डैमेजेस, राइट? अगर द डॉक्टर वांट्स टू अवेल दिस डिफेंस की वॉलंटरी नॉन फिट इंजूरिया, इसका मतलब ये है कि उसने जो भी किया है, यू हैड ऑलरेडी अग्रीड टू इट, आइदर इम्प्लाइड अग्रीमेंट था, लेकिन वो फ्री होना चाहिए, वॉलंटरी होना चाहिए, यू हैड द फुल नॉलेज कि मैं अगर ये प्रोसीडियर या ये सर्जरी अंडरगो करूं, आई एम अवेयर ऑफ द रिस्क्स इट एंटेल्स, मुझे कोई साइड इफेक्ट्स फेस करना पड़ सकता है, एंड द डॉक्टर आल्सो ओज अ ड्यूटी टू मेक यू अवेयर ऑफ द एक्सटेंट ऑफ रिस्क. So if you have already agreed to incur it, then you have to waive and you have already waived any claim for injury, then this defense will be available. But when the plaintiff has no choice, or when the notice is given at a stage when it is beyond the ability of the plaintiff to make a choice, there can be no implied agreement, and the defense on the basis of this maxim must fail. मतलब अगर डॉक्टर सर्जरी के बीच में तुम्हें बोल रहा है कि ये सर्जरी से तुम मर सकते हो, and there is no actual choice for you, तुम वहां मना तो नहीं कर सकते ना कि आधा सर्जरी खत्म हो चुका है ऑलरेडी, so you do not have an actual choice, there is no implied agreement, because तुम्हें पहले से doctor had not made you aware of the risks the surgery entailed. So यहाँ पे the doctor will not have the defense of this maxim. The maxim will also not apply when the act relied upon is done because of the psychological condition which the defendant's breach of duty had induced. एक plaintiff है and एक defendant है. Defendant ने अपनी duty breach करी, जिसकी वजह से plaintiff में एक ऐसा psychological condition आ गया कि मतलब he or she has to do it. So वहाँ पे भी consent actual नहीं है, and the maxim will not be applied. We'll delve into a few questions now. So is anyone interested in reading out the first question, 66? I hope it's visible to you. All right, I'm reading it and then you will answer it because the answer is not visible here. Mr. A was the owner of a car and he had a driver, Mr. D. Okay, A है owner car का and he has a driver, Mr. D. On January 19th, 2021, in such passages, just, if it's not a contract-based passage, usually dates do not have any significance. So you can just skim through these details. The wider important part is the options. You have to pay a significant amount of attention to these options and then choose the answer. The situation you can kind of rush through. A और D कार में ट्रैवल कर रहे थे, A ओनर था कार का, तो A चला गया एक रेस्टोरेंट को और D को बोला कि मेरे बंगलो में वापस ले जाओ. जब D पेट्रोल फिल कर रहा था, दो स्ट्रेंजर्स B एंड C बोले D को कि हमें एक लिफ्ट दे दो. सो D अग्रीड और B एंड C को लिफ्ट देके कार में चला गया. वहां पे क्या हुआ ना, एक एक्सीडेंट हुआ. मिस्टर D एंड मिस्टर C वर थ्रोन आउट. मिस्टर C के सिवियर इंजरीज हुए एंड वो मर गया. मिस्टर D के अगेंस्ट कॉम्पेंसेशन फाइल करने के लिए मिस्टर B जो कि मतलब जिंदा है एंड मिस्टर C जो मर गया एक्सीडेंट की वजह से, उसके लीगल रिप्रेजेंटेटिव्स आर नाउ सीकिंग कॉम्पेंसेशन फ्रॉम मिस्टर A एंड मिस्टर D. सो A कार का ओनर था, D कार का ड्राइवर था. D ड्राइव जब कर रहा था तब B और C थे कार में जो कि लिफ्ट लिए थे एंड वहां C बाहर गिर के मर गया. D को शायद मतलब उतना कुछ हुआ नहीं, D अभी जिंदा है. So अभी वो पूछ रहा है कि ये जो compensation है under law of torts, can it be availed from Mr. A and D? Option A says कि हाँ D को देना चाहिए compensation, right? D ड्राइव कर रहा था तो उसको compensation देना चाहिए. B says कि no, इधर defense है. Defense क्या है? Voluntary non-fit injuria will be applicable and no compensation can be claimed. C, voluntary non-fit injuria will not be applicable and compensation can be claimed. Exact opposite है. और ऑप्शन डी बोल रहा है कि सिर्फ डी नहीं, ए और डी दोनों लायबल हैं कॉम्पेंसेशन देने के लिए. सो लेट्स गेट टू वर्क. क्विकली आंसर मी, व्हिच ऑप्शन डू यू फाइंड द मोस्ट अप्रोप्रिएट हियर?
बी.
Okay, option B. Does anyone else have any other opinion? So here, B and C willingly, voluntarily consented to the risk of any accident when they took a lift from Mr. D in the car. So that is why this maxim will be applicable. Voluntary non-fit injuria will be available as a defense, and compensation तुम claim नहीं कर सकते. When you are entering into an Uber, let's say, and अगर Uber वाले की कोई गलती नहीं है, okay, of course अगर वो Uber वाला drunk था and accident हो गया, then तो he will be liable. बट अगर वो नॉर्मल चल रहा था, रीजनेबल मैन की तरह ड्यूटी ऑफ केयर हो करके सारे ठीक ठाक चल रहा था, फिर भी एक्सीडेंट हुआ, यू कैन नॉट फाइल अ केस अगेंस्ट द कंपनी कि हमें कॉम्पेंसेशन दो, राइट? सो हियर आल्सो वॉलंटरी नॉन-फिट इंजुरिया विल बी एप्लीकेबल. 67 says Rama was a spectator at a motor car race. ट्रैक में चल रहा था जो डिफेंडेंट कंपनी जिसके अगेंस्ट केस फाइल किया गया है. रेस के वक्त क्या हुआ, 2 cars collide किए, one of the cars was thrown among the spectators and Rama was severely injured. So अभी क्या इनमें से कौन सा statement correct है? The first option says Rama impliedly took the risk of such injury, the danger being inherent in the sport which any spectator could foresee. मतलब जो भी जाके बैठ रहा है ये sport देखने को, he or she already knows कि इसमें एक inherent danger है, and she implied took the risk and the defendant was not liable. It was a negligence on the part of the defendant and voluntary non-fit injury will be applicable. Rama did not take the risk of such injury and she only consented to watching the race and hence the defendant was liable. Rama was negligent and hence she suffered injuries. So first of all, answer तो दिया हुआ है, लेकिन अगर ना भी दिया हो, so option elimination से चलो. Firstly, option D is straight out incorrect. ऐसे options usually incorrect होते हैं जो कि ऐसे suggestive होते हैं या accusatory tone के होते हैं. What the consortium will want you to do is to choose an option which lays out the reasoning in a mature manner. रामा को negligent कैसे बोल सकते हो? वो मतलब मोटर कार रेस देखने गए इसलिए उसको जज करके negligent बोल रहे हो? वो these options are of course not viable for the correct option. Next, B बोल रहा है कि negligence है defendant के part में and voluntary non-fit injury will be applicable. Look, अगर negligence है defendant के part में तब तो ये maximum applicable नहीं होगा ना. अगर वो मोटर कार रेस कुछ नेग्लिजेंट हुआ है, if they were lacking in the whatever duty of care they owed, then तो ये maximum applicable नहीं होगा, ये डिफेंस वो नहीं ले सकते. So option B is also ruled out. We remain with option A and C. So look, here some people may opt for option C thinking कि अच्छा वो तो सिर्फ बैठी थी देखने को, वो थोड़ी सोची थी कि आके ऐसे कार मुझे हिट कर लेगा. But keep in mind, I had already given you an example of a cricket or football match. जब तुम स्टेडियम में जाके बैठ रहे हो, you are aware कि बॉल आके तुम्हारे सर को भी हिट कर सकता है at any moment. So that is why this is an implied agreement. ऐसा नहीं है कि तुम बैठने से पहले पूरा एक्सप्रेस एग्रीमेंट साइन करो कि हाँ आई अग्री कि अगर मुझे कार हिट करे देन मैं कॉम्पेंसेशन फाइल नहीं करूंगी. नो, दैट इज नॉट व्हाट एग्जैक्टली हैपेंस. दैट डज नॉट मीन कि कंसेंट यहाँ नहीं है. यहाँ पे कंसेंट है. कैसे है? देयर इज एन इम्प्लाइड फॉर्म ऑफ कंसेंट. सो शी अग्रीड टू द रिस्क ऑफ सच इंजरी, द डेंजर बीइंग इनहेरेंट इन द स्पोर्ट व्हिच एनी स्पेक्टेटर कुड फोरसी. कोई भी नॉर्मल आदमी जो भी जाके देख रहा है, he or she knows कि ऐसा हो सकता है. The next question, which is correct about consent in voluntary non-fit injury? It's very easy. It's a straight question. It's a straight statement from the passage. Knowledge of the risk does not always amount to consent. Just because तुम्हें risk पता है, उसका मतलब ये नहीं कि तुम consent कर रहे हो. Consent करना मतलब तुम risk पता है and voluntarily agree कर रहे हो risk को, मतलब वो harm suffer करने को. Let's look at other options. Knowledge of a risk does not precede consent. बोल रहे हैं कि knowledge of risk जो है वो consent को precede नहीं करता. कैसे नहीं करता? You have to be aware of the risk. उसके बाद तुम consent दोगे ना. So of course it precedes. Knowledge of the risk always amounts to consent? No. It may be that you are aware of the risk, but you have not consented to it. Mere perception of existence of danger amounts to consent. No. Just because तुम्हें पता है कि अच्छा शायद कोई dangerous चीज हो सकती है, that does not mean कि तुम consent कर रहे हो. You have to specifically have already voluntarily agreed to suffer the harm. The next question. Lily had placed spring guns in a wood on her ground for the protection of the garden. Karan, with full knowledge that there were spring guns somewhere in the wood, trespassed on the land of Lily and was injured. Which of the following statements is correct? Can someone read out the options and tell me why option D has been stated as the correct one? Feel free to do so. There is absolutely no.
By knowing willfully that there were spring guns in the woods, he consented to the danger that he would get hit by one of those spring guns. Hence, option D is the correct answer.
Very good. So see, if अगर यहाँ पे option D answer correct है, ये दिखाई नहीं दिया होता, I'm pretty sure a lot of people might have thought कि मतलब कारण ने तो खुद trespass किया है, so he is liable for something, so why should he get compensation? So someone might have chosen option C कि यहाँ पे voluntary non-fit injury नहीं आता, यहाँ पे तो plaintiff is the wrongdoer defense आता है. We'll read about another defense, the second defense. Plaintiff is the wrongdoer, जो अपना outside knowledge apply करेगा, वो ये सोच लेगा. But keep in mind to stick to the amount of information which has been given to you in the passage. They only expect you to apply the principles which have been given to you. And based on that, option D is absolutely the correct answer. Karan had the knowledge of spring guns and willfully quoted the danger himself, which means यहाँ पे क्या हुआ है? Voluntary non-fit injury का है मतलब defense. Lily will not be liable उसके लिए. Lily has not committed a tort against Karan by exceeding her right or private defense. See, here exceeding her right of private defense, ये सारी चीजें अलग defenses हैं torts पे. यहाँ पे the passage does not deal with them. We should not get blindsided or sidetracked. Which of the following is not an element to claim the defense of volenti non-fit injuria? So इस defense को claim करने के लिए क्या क्या चाहिए? Firstly, there must be a prior knowledge of the plaintiff about the risk involved. Absolutely correct. There must be free consent. Yes. Plaintiff is compelled to agree to a risk by defendant. No. Voluntary acceptance of the risk by the plaintiff. Yes. So ABC तीनों ठीक हैं. मतलब ये तीनों elements होने चाहिए to claim this defense. अगर तुम्हें कोई forcibly agree करने को बोल रहा है, then your consent is not free, right? So that is why option C is the correct answer. Does anyone have any doubts regarding to this passage and its associated questions?
One question which had come in a book is that there was a farmer and then there is a goon. The goon had pointed a gun at the head of the farmer and told him to give his land. The farmer, under this forcefully was forced and coerced, and he then signed the contract under which he gave the land to A. Later, when asked about this, A said that he willingly gave it. So now, will this be valid or will this be a coerced contract?
So are you saying later on the farmer said कि नहीं मैंने मतलब I had given it willingly?
Yeah.
No, it does not matter whatever he says later on. When his consent was obtained, it was obtained under duress. It was not free consent, and that is why it will not be a valid contract पहले से ही.
Okay, so it's a void contract.
Yeah, this is not exactly under law of torts. I think it's about agreements or consent ka thing. Okay. All right. So the next defense we have is plaintiff is the wrongdoer. So let me make it clear to you. Plaintiff is the person जो कि case file कर रहा है against another person seeking damages. Okay. मतलब उसका कोई right violate हुआ है plaintiff का और वो defendant से damages चाहता है. हम जो पढ़ रहे हैं these are defenses. मतलब these are things that the defendant can use to avoid paying the damages. यहाँ पे क्या हो रहा है कि जो केस फाइल किया है जिसके राइट्स वायलेट हुए हैं वो तो खुद रॉन्ग डूअर है. मतलब the law excuses the defendant when the act done by the plaintiff itself was illegal or wrong. मतलब example से समझ लो, a person who tries to illegally enter a house and gets bitten by a defendant's dog cannot then claim compensation under the law of torts as the plaintiff himself was the wrongdoer, making this a valid defense for the defendant. तुम किसी के घर में चोरी करने जा रहे हो और वहां पे let's say their dog bites you, you cannot file a case against the homeowner कि तुम्हारे dog ने मुझे काट लिया, right? Because here you are in the wrong first of all. That is why this is a valid defense, and this is why I talked about this question. Here some people may think that वो trespass किया है तो ये तो voluntary non-fit injuria है नहीं, तो इतना नहीं सोचना. You have to talk about the principle and check कौन सा option सबसे ज्यादा लग रहा है, best possible answer. So I hope this defense is clear. Third defense we'll talk about is inevitability.
What if the plaintiff was invited?
Yeah, if he was invited, then the person who had invited him owed a duty of care to that person. And अगर वो negligently उसके dog को allow करता है ऐसा कुछ करना, then he or she may be liable to give damages to that person. So this defense is only available here because the plaintiff is in the wrong. Okay. Let's say तुम किसी को घर को invite किए हो और तुम्हारे घर पे ऐसे एक landmine type सा कुछ है, and the person stepped on it. यहाँ पे कुछ एक bomb blast हुआ and the person was injured. So of course you will be liable to pay damages to that person because you owed a duty of care to that person. You do not have this defense in that case. Third defense is inevitable accident. मतलब जो हुआ जिसकी वजह से damages कोई face किया वो एक accident था जो कि होता ही होता despite reasonable care on the part of the defendant. That is why defendant के पास ये defense है और जिसको वो use कर सकता है when the injury is caused to a person by an event that could not be foreseen and avoided. Okay, मतलब सारा try करने के बाद भी वो होना ही था. इसके लिए we'll read a case here, श्रीधर तिवारी versus UP State Road Transport Corporation. And here एक बस था जो कि वो जा रहा था village के पास. A cyclist suddenly came in front of the bus. बस के सामने एक cyclist जब आ गया, बारिश हुई थी, रोड वेट था, ड्राइवर ट्राई किया अवॉइड करने को साइक्लिस्ट को. The driver applied brakes. So the road was slippery. The bus skidded on the road and hit the rear portion of another bus which was coming from the opposite direction. वो skid करके, slip करके किसी और बस के other portion को hit कर दिया oppositely. It was found that at the time both buses were being driven at a moderate speed, मतलब ठीक ठाक चल रहा था सब. Accident had occurred despite due care on the part of the drivers of both the buses. It was held that accident had occurred due to inevitable accident and therefore the defendant corporation was held not liable for the same. मतलब अगर वो बस के जो बैठे थे passengers, if they perhaps one of them was Sridhar Tiwari, if he filed a case against UP's State Road Transport Corporation who owned the bus, they were not liable to pay any kind of damages to that person because either both the bus drivers tried their best to avoid it and it was an inevitable accident which could not be foreseen and avoided despite reasonable care. I hope it's clear. The fourth point is an act of God. It is something that we talked about in contracts as well when we were discussing force majeure clause. In contracts, an act of God is also the same thing. जहाँ पे तुम किसी breach of contract को avoid कर सकते हो. Let's say you had agreed to give like 5 kg of rice to someone, and उसके बाद क्या हुआ ना, unexpected level of मतलब इतनी ज्यादा बारिश हुई जो कि कभी दुनिया में नहीं हुई होगी. There is an act of God जो कि तुम कुछ नहीं कर सकते थे, and that's why your rice is spoiled and you are allowed to breach the contract without having to pay damages there. जबकि वो कॉन्ट्रैक्ट केस था. यहाँ पे वी आर डिस्कसिंग इन टॉर्ट्स. इन द कॉन्टेक्स्ट ऑफ टॉर्ट्स, एक्ट ऑफ गॉड, जिसको हम विस मेजर भी बोलते हैं, can be defined as circumstances which no human foresight can provide against, any of which human prudence is not bound to recognize the possibility of, and therefore are calamities that do not involve the obligation of paying for their consequences. एक्ट ऑफ गॉड और इनेविटेबल एक्सीडेंट के बीच डिफरेंस क्या हुआ? इनेविटेबल एक्सीडेंट के में भी कोई ऐसी चीज हुई है जिसको अवॉइड नहीं किया जा सका डिस्पाइट रीजनेबल केयर. एक्ट ऑफ गॉड में भी ऐसी कोई चीज हो रही है जिसको तुम कभी प्रेडिक्ट नहीं कर सकते थे. But the difference here is act of God imply करता है it is due to natural forces and is an extraordinary occurrence that cannot be anticipated. जबकि ये inevitable accident मतलब कोई ऐसी चीज हो रही है जैसे यहाँ पे cyclist आ गया, that's not an act of God, right? अगर एक earthquake हो गया unexpectedly and कुछ damage हो गया जिसकी वजह से तुम अपने products नहीं dispatch कर पा रहे, that will be an act of God. That will not be an inevitable accident. Accident is different from act of God. I hope you understood that. We'll understand act of God from two particular examples. So this is the case. The case is something versus Marsland, in which the defense was successfully argued. In this, the defendant created some artificial lakes on his land by damming some natural streams. Defendant ने क्या किया? कहीं कहीं जगह पे streams जा रही थी, वहां पे dams construct करके एक खुद के land पे artificial lakes बना लिया. Extraordinarily heavy rainfall हुई, which was stated to be the heaviest in human memory, as a result of which इसने जो artificial lake बनाया था, embankments मतलब जो वो guard कर रहे थे उसे, they gave way, मतलब वो टूट गए. Water rushed out and washed away 4 bridges belonging to the plaintiff. Plaintiff मतलब जिसने case file किया है, the one who faced this damage, जिसके bridges wash हो गए. It was held that the defendant was not liable for the loss had occurred due to the act of God. I hope you understood here. जो बारिश इतनी एक्स्ट्राऑर्डिनरी लेवल हुई है जो कि कभी नहीं हुई थी, दिस वाज एन एक्ट ऑफ गॉड एंड यहाँ पे कोई कुछ नहीं कर सकता था. इवन दो आर्टिफिशियल लेक मतलब टूट गए, he perhaps had taken all reasonable steps, उसके embankments ठीक ठाक थे, बस they could not withstand the force of that much rainfall. Lekin, there is another parallel case in Kalulal versus Hemchand. The wall of a building collapsed on a day when there was heavy rainfall that resulted in the death of respondents' 2 children. The MP High Court stated that the defendant could not take the defense of act of God in this case, as that much of rainfall during rainy season was not something extraordinary, but which could be anticipated and guarded against. So I hope you understand. In the first case, the rainfall which occurred was extraordinarily heavy. उसको कोई expect नहीं कर सकता था. The embankments which broke down were not due to the negligence on the part of the defendant. But इधर एक wall है तो मतलब भारी बारिश के वक्त तो of course there is a danger to all sorts of construction. So you were supposed to have guarded against such possibilities and you should have anticipated कि कभी ना कभी तो बारिश होगी. That is why you do not have this defense here. We'll move on to another defense, the right of private defense. Okay. So the private defense means every person has a right to defend his own body and the body of any other person against any offense affecting the human body and the property, whether movable or immovable, of himself or any of other person. So तुम्हारे पास एक right है खुद की body को defend करने को, किसी और की body को defend करने को, against क्या? कोई एक offense कोई कर रहे हैं अगर तुम्हारे body के खिलाफ या फिर तुम्हारे property के खिलाफ, वो property movable हो सकती है, immovable हो सकती है, तुम्हारी हो सकती है, किसी और की हो सकती है. क्या क्या requirements satisfy करने हैं to avail this defense? The defendant must be under threat or attack. See, plaintiff file कर रहा है एक case. Let's say तुम किसी के घर में घुस गए थे and you had attacked them and they shot you. गन से, you are filing a case against them कि he shot me. Of course, the person who shot you had the right of private defense. क्यों? Because the defendant was under threat or attack. The response must be necessary for self-defense and not for retribution. Let me make it clear, तुम गन जब फायर कर रहे हो तब वो सिचुएशन होनी चाहिए जबकि तुम थ्रेट या अटैक के अंडर हो. So you need to fire the gun for your safety, for your self-defense. It must not be for retribution. मतलब ऐसा नहीं होना चाहिए कि तुम किसी के अगेंस्ट मतलब रिवेंज ले रहे हो इसलिए फायर कर रहे हो फिर बोल रहे हो कि सेल्फ डिफेंस है. द रिस्पॉन्स मस्ट ऑल्सो बी प्रोपोर्शनेट टू द अटैक और थ्रेट. सी, अगर
But,
5 चोर आए तुम्हारे तरफ, they tried to snatch your gold chain. You took out your gun and pointed it at them. The chore, they got scared and the thieves ran away. They are already running away. You are no longer under threat or attack. तुम्हारे प्रॉपर्टी के खिलाफ जो अटैक था, that's no longer there, but you are still firing the gun and you are shooting someone dead. That means that your response was for retribution, वो self defense के लिए necessary नहीं था. And the response must also be proportionate. अगर तुम्हें कोई मतलब ऐसे suppose you are suddenly getting some kind of a surprise, तुम्हें कोई आके तुम्हारे सामने ऐसे चौंका दे रहा है and you are like taking out a knife and stabbing them, that's not an appropriate response, right? So your response must also be proportionate. Illustration. A is attacked by a mob who attempts to murder him. A को एक mob attack करती है murder करने को and A को पता है कि बिना फायर करे मैं कुछ नहीं कर सकता, खुद को नहीं बचा सकता. बट अगर वो फायर करता है देन वो यंग चिल्ड्रन भी हैं वो मॉब के अंदर एंड उनको हार्म पहुंच सकता है. हियर अगर वो फायर करता है एंड कोई चिल्ड्रन हार्म फेस करते हैं, A commits no defense because he has the right of private defense. Anyone has any doubts with regarding to this page?
But the right to private defense and self-defense should not exceed like a limit, that is someone's death.
True. The response must be proportionate to the attack or threat.
Like if
That's what I said.
someone is not attacking you, he is just only verbally saying that he will attack you, and you just shoot him.
Yeah, that would be something that is decided on a case-to-case basis, right? Depending upon the facts. If someone is using verbal intimidation, you might be under the threat or attack. It can also be perceived that way. Because अगर तुम्हें कोई धमकी दे रहा है, you do not know कि वो धमकी सच में दे रहा है या ऐसे ही बोल रहा है, right? So you will of course assume कि वो सच में बोल रहा होगा, and your self-defense can be stemming from that as well. So that is something that will be analyzed by the court depending upon the facts of that particular case. So this is the last two defenses which a person can avail under law of torts. First, the sixth one is necessity. Certain intentional damage is excused when done for the greater good of the people or to avoid any greater harm. मतलब ऐसा कोई डैमेज हो रहा है जो कि इंटेंशनली किया जा रहा है, लेकिन वो कोई कर रहा है, क्यों कर रहा है? फॉर द ग्रेटर गुड ऑफ द पीपल, टू अवॉइड कोई ज्यादा हार्म, कोई बड़ा हार्म को अवॉइड करने के लिए छोटा हार्म के लिए सेटल कर रहा है. It can be distinguished from private defense as it involves the infliction of harm on innocent people, whereas the plaintiff himself is the wrongdoer. So see, necessity के case में you are inflicting harm upon some people who are innocent. उन्होंने कुछ किया नहीं है. जबकि in private defense what we had was the defendant जो कि suppose खुद को defend कर रहा है किसी को मार के या मतलब ऐसे defend करके fight में, वो क्यों कर रहा है? जबकि बिकॉज जिसके अगेंस्ट वो कर रहा है ही इज द रॉन्ग डूअर, मतलब ही इज कमिटिंग सम काइंड ऑफ अ थ्रेटफुल एक्ट, जबकि यहाँ पे इनोसेंट लोगों के अगेंस्ट हो रहा है हार्म. इट इज ऑल्सो डिफरेंट, नेसेसिटी इज ऑल्सो डिफरेंट फ्रॉम इनेविटेबल एक्सीडेंट. कैसे? इनेविटेबल एक्सीडेंट में मतलब द हार्म हो ही रहा है डिस्पाइट बेस्ट एफर्ट्स टू अवॉइड द सेम, जबकि नेसेसिटी के केस में हार्म इज इंटेंडेड. कैसे? विल अंडरस्टैंड फ्रॉम दिस इलस्ट्रेशन. A is the captain of a steam vessel. Okay. Without any fault or negligence on his part, he finds himself in such a position that before he can stop his vessel, चला रहा है वो vessel को, ship को, he must inevitably run down boat B with 20 or 30 passengers on board unless he changes the course of his vehicle that carries the risk of running down a boat C. So unless वो अपने track को बदलता है, he carries the risk without any fault or negligence on his part कि बोट बी पे वो चढ़ जाएगा, 20 और 30 लोग मर जाएंगे. बट अगर वो बदलता भी है, ही कैरीज द रिस्क ऑफ रनिंग डाउन अ बोट सी जहां पे सिर्फ 2 पैसेंजर्स हैं. अगर यहाँ पे A, who is the captain, alters his course in good faith to avoid the danger to the passengers in boat B, क्योंकि वहाँ पे 20 या 30 लोग हैं, अगर he runs down boat C, he will not be guilty of an offense. I hope you understood here. Here, the harm is intended. The harm is occurring against innocent people. But why is it being excused? Only because of the fact that it is trying to avoid the greater harm and it is striving for the greater good of the people. Is it clear? We'll head to the last defense which we have. Acts done under statutory authority. When the commission of what would otherwise be a tort is authorized by a statute, the injured person cannot avail remedies. मतलब जो कि otherwise एक tort के अंदर damages seek कर सकता है, लेकिन उसको कोई एक act है जो अब मतलब statute है वो authorize कर रहा है. For example, the power मतलब किसी पुलिस वाले के पास है कुछ करने को, जो कि कोई और करता तो शायद वो tort के अंदर आता. But the powers conferred by the legislature should be exercised with judgment. मतलब ऐसा नहीं है कि तुम्हें जो statutory authority मिली है तुम कुछ भी use कर लो उसे. You must do so with caution and judgment so that no unnecessary damage is done. The person must do so in good faith and must not exceed the powers granted by the statute. Otherwise, he will be liable. Illustration. So यहाँ पे एक case है जहाँ पे sparks from an engine of the respondent's railway company, which had been authorized to run the railway, set fire to the appellant's woods on the adjoining land. See, you are owning certain amount of land जिसके side पे एक railway track जा रही है. Okay, वो railway चलाने को एक company authorized है. उस कंपनी के रेलवे ट्रैक में ट्रेन चलते वक्त वहां पे एक इंजन से स्पार्क निकल के तुम्हारे लैंड पे जो जंगल है वहां पे आग लग रही है. It was held that since the respondents had taken proper care to prevent the emission of sparks and they were doing nothing more than what the statute had authorized them to do so, they were not liable. मतलब वो रेलवे कंपनी जो है उसको there is an act which has authorized them to run the company and they have done so with proper care to prevent emission of sparks. And वो statute में जितने safety measures लेने को बोला जा रहा है वो सारे उन्होंने follow किया था. So they did everything they could, but something still happened, so they are not liable. The same proportion was against Treston in another case. So let me make it clear, this is not inevitable accident, because यहाँ पे शायद से वो fire को मतलब prevent किया जा सकता था, लेकिन the fact is the company was under the legal authority to do so, and जब तक उसने कोई negligent काम नहीं किया है, proper care लिया है, तब वो जो भी damage होता है, they are not liable for it. So with that, we come to an end to today's session. We'll talk more about torts, which is a really large syllabus later on. So for now, I'd like you to ask any kind of doubts which you may have.
Regarding
Sure,
the UPSRTC case, imagine if it, let's say, that took place in Gorakhpur and there was snowfall in their region, then will it now be considered as act of God?
Look,
Since the road
no,
was slippery due to ice.
No, act of God is something that is only considered when the accident which has occurred, it is due to something extraordinary and which could not be foreseen. Their inevitable accident इसलिए नहीं हुआ कि बारिश हुई थी. बारिश होना is normal. It is not an act of God. मतलब in the context of law. वहां पे inevitable accident इसलिए बोला गया क्योंकि the cyclist suddenly came in front of the bus. The bus tried its best to maneuver and then still hit another bus. इसलिए that became an act of God. Snowfall हो या rainfall हो, ये सारी चीजें act of God नहीं कहलाएंगे जब तक the thing is not anticipated. is something जो कि foresee नहीं कर सकते तुम. Sudden एक earthquake हो गया, right? So that is an act of God. या फिर extraordinarily amount of heavy rainfall हुई जिसकी वजह से कोई damage तुम्हें पहुंचा. That will be an act of God. That won't be an act of God. Because यहाँ पे तो वैसे भी बारिश होके skid किया था. So it was just an inevitable accident. So any other doubts? We'll discuss in length about torts. There are a lot of interesting things left. As he raised the question of Bhopal gas tragedy, we have a passage based upon it regarding strict and absolute liability, vicarious liability. We also have various specific torts which we'll study about: assault, battery, trespass, nuisance, defamation, and yeah, so we'll talk about remoteness of damages and a few other maxims as well. So this will probably take a few more classes, and I hope you join the next time as well. If anyone does not have any doubts, yeah.
I have a doubt, like if a person has set up some electric field around his electric wires around his field, and uh, other person's cow entered it, and it got shocked or it died, so will that person who's set up that wire, will he be held liable?
The situation requires a lot of more facts. Like, was the person who had set the wires legally allowed to do so? Was that his land? And had he taken
It was
every
his land, but he did not like put any board or something like to catch someone's attention, or
yeah, then he will be liable under torts, even though the plaintiff who is the wrongdoer. यहाँ पे भी कोई exceptions होता है. Like, let's say कि उसके land पे ये लोग trespass भी कर लिए. हाँ, वो trespass किए हैं, but still उतना ज्यादा भी नहीं होना चाहिए ना damage. So under that, some exceptions are there. If he had not taken any reasonable foresight to warn others कि beware of wiring, या फिर he had not taken proper steps to insulate the wire so that किसी को damage ना लगे. So he failed the duty of care that he owed to others. There is a moral duty that is imposed by law upon you as a resident of society. So yeah, he will be liable. Anyone else? So I'm ending the session here. I hope you join the next time. Thank you and all the best for your preparation. Keep learning.